at 8:35 a.m.
Good morning, Mr. Chapman.
Good morning, Your Honor.
You can proceed when you're ready.
Thank you.
Good morning also. Good morning also.
Good morning.
In each of these matters, Mr. Johnson is here today after failing to appear before referee Delmont on May 8th, 2023. Bond in each case is currently set at $500. This is the fifth bench warrant in the 2008 case and the fourth bench warrant in the other two cases. He reports that he is employed at WHC Solar Panel. Last payment made on these accounts was in July of 2023. The court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on November 8th, 2023 at 8 o'clock a.m. before this court.
Okay, thank you. Mr. Johnson, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on November 8, 2023 at 8 o'clock a.m. You will get notice of that in writing. Are you able to post a bond, sir?
First again, I just feel good when we all say good morning to each other. I just want to say that again. That just made me feel good.
Okay.
But I never knew about none of these court dates. Also, before WAC, I was working at Tentacle and they was taking child support out of my check. I've been working like for the last 2 years. So I'm really kind of like not understanding it because I came down here several times to the friend of the court down in the basement and told them that I was working and they started taking money out of my check. And I've been, excuse me. And I've been working at WAC for like 90 days. Like I say, before that, I was working at Tentacle as a welder. And I worked 13 days straight, 12 hours a day. I'm a supervisor for 47 people. Really turned my life around. Sandria Parks, Emily Parks, which is my daughter. I just gave her 200 yesterday. My son, Dwayne Johnson, I've been spending time with him, bought him a car. Now he's trying to get his permit. I just didn't know nothing about all these warrants. And I've been around.
Okay.
And I don't understand how I even had all these warrants.
Okay. Well, what happens is oftentimes when people move, they don't change their address. And when you don't change your address for the court, they send it to your last known address.
Okay. Well, I've been staying at my house for over 10 years.
Well, okay.
Now, I have got out of prison. I did get out of prison quite some time back. But since getting out of prison, I don't work at AC Foundry. They was taking child support. I don't work at Clemens. They was taking child support. I don't work at Tentacle Magnum. They was taking child support. Now at WAC, and then they automatically sent a paper out to the friends of the court. I just don't understand how I even got warrants when I'm already.
On WHC, obviously, you said you've been working there for approximately 90 days, which would be about the time that they haven't been collecting support. So have you seen support taken out of your check at WHC?
My check stuff, I need to set up this email thing. It's a little different than working in factories. It's a little more of a career. I haven't seen it, but I assume they was.
Well, you can't assume, sir, because if you assume, then that's the problem is that if they're taking it out, then you're going to be dragged into court like this.
Yeah, I see, Your Honor.
Are you able to post a bond, sir, in these cases?
I probably got $500 on my debit card. Like I've been paying my insurance, paying my bills and stuff. I don't get paid until Thursday, but I do have $500 to my name.
What I'm going to do is I'm going to set your bond in each case in the amount of $100. So it'd be $300. You can post that, and then you'll be able to be released. Do you have any questions?
No, sir. Just that I've been doing good. I ain't been in jail in a long time, so.
Well, then you'll have to appear back on the November 8th date. You can speak to your caseworker and get everything worked out. You may not have to come back on that date. Okay?
Okay.
Okay. Thank you, sir. You're free to go. Have a good day.
Thank you, sir.
Mr. Fonseca is here today after failing to appear before this court on July 26, 2023. Bond is currently set at $5,823. This is the second bench warrant. He reports that he is employed at DoorDash. last payment made on this account was in April of 2022. The Calhoun County Sheriff's Department is requesting transportation cost reimbursement in the amount of $42.29. The court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on November 8th, 2023 at 8:45 a.m. before this court.
Mr. Von Sika, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on November 8th, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
Depending on if it's reasonable.
Okay. Well, you have a sizable arrearage, obviously, in this particular matter, but the court is taking into account it is your second bench warrant. So what I'm going to do is what? Go ahead.
I'm sorry. I had a family emergency down in Louisiana that I had to attend. My sister passed away back in July. That's the only reason I missed court.
Well, there's things you can do, sir. If you're going to have to miss court for something like that, you can always call us and we can reschedule the court hearing. You just can't.
I just got me a phone. I've just got a phone.
I'm sure you know somebody with a phone. You just can't not contact the court and assume we're going to know what's happening, you know?
Yeah, I spent the last 2.5 months in jail already.
Okay. Well, what I'm going to do is I'm going to reduce your bond in hopes that you could be released pending that hearing. I'm going to set your bond in the amount of $500. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. You're excused. Have a good day.
Yes.
No.
Mr. Case is here today after failing to appear before this court on July 21st of 2021. Bond is currently set at $500. This is the first bench warrant. He reports that he is employed at Tenneco. Last payment made on this account was in August of 2019. The court recommends that a reasonable bond be set on this matter and it be scheduled for hearing on November 8th, 2023 at 8:45 a.m. before this court.
Thank you. Mr. Case, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on November 8th, 2023 at 8:45 a.m. Are you able to post a bond, sir?
No, I'm not. My wife passed away, so I ain't been able. She died of COVID. I've been having it rough. I lost my house. I just got a job starting at Tenneco. I was supposed to start last night, and I went to jail Saturday night. My wife died of COVID.
Okay.
I watched her take her last breath.
Okay. And that's relevant to how, sir?
I mean, it messed me up. It messed with me. I'm sorry.
Okay.
I'm very sorry.
Well, your hearing was over 2 years ago. You could have contacted the court within that 2 years and made arrangements or at least talked to someone. So,
I did talk to someone. I did try to talk to someone.
well, you didn't talk to him if you tried to talk to him. You said first you talked to someone, then you said you.
Well, I mean, I'm sorry. I tried to call up here and talk to somebody. I didn't.
Okay, so now you didn't call. You just tried to call.
Yeah, I did try to call and didn't get nobody. I'm sorry. You know, I'm sorry, Your Honor.
Yeah. Well, what I'm going to do is I'm going to reduce your bond because it is your first bench warrant in this matter. What I'm going to do is I'm going to set your bond in the amount of $100. If you're able to post that, you'd be able to be released. Do you have any questions?
No.
Okay.
If not, how long do I got to stay?
Excuse me?
If I can't post it, how long will I be here?
You'll be there until the hearing on November 8th. Okay. You're excused. Have a good day, sir.
Thank you.
8 a.m. Attorney
Thank you,
Lisa
Mr.
McNiff for
Chapman.
plaintiff and
Thank you, Your
attorney
Honor.
Aaron
Have a good day.
Martell for defendant.
Good morning to both of you. Court will note that this matter is before the court on the plaintiff's notice for entry of judgment of divorce. Proofs were previously taken and preserved in September. Where are we at in the case, Ms. McNiff?
Your Honor, we mediated on August 29th, and then as you said, we had the pro-con on September 5th. I haven't heard from Mr. Martell since approximately September 12th on this case. I understood that his client was not working. We had earlier imputed him income at $15 an hour for 40 hours a week. That's what's in the child support calculation. I haven't heard anything from Mr. Bartel objecting to the judgment or to the child support order. So I'm not sure what the holdup has been, but we needed to get it entered.
Oh, okay. Mr. Bartel, what's
Your
your
Honor,
position?
we're not going to object, Your Honor. There was some confusion on this end, so I apologize, but there's no objection, so it can be entered.
Okay. Court will enter the judgment as submitted by Ms. McNiff. That will conclude your case.
23 at 8:50 a.m.
Have a
The
good day.
Plaintiff is
Thanks.
All right,
not
thank you.
here.
You too.
Okay. Ms. Gilman, good morning. Could you enlighten me what's happened with Mr. Hanker? Have you had contact with him, or why isn't he here if you know?
I don't know why he hasn't contacted me. And last time I knew, he had woken up from in the hospital, but I haven't heard anything since.
He had what?
He had woken up for a day or two in the hospital, and I haven't heard anything since. I
Okay, so
haven't spoken
he's
directly.
hospitalized then?
Yes, he got into an accident October 1st.
Okay. Well, what I think we'll do in that case, not knowing, what we'll do is reschedule this and give him opportunity. Hopefully he'll be doing well or better, and we can get him in, and then we can proceed. Okay,
How far out should we reset it?
about a month.
Okay.
Anything else, Ms. Gilman?
No.
23
Okay.
at 8:52 a.m.
Well, you're free to go. Have a
Attorney
good day.
James Fisher for plaintiff and Attorney Shelley Hoffman for defendant.
Good morning to all of you.
Morning.
Court will note that this matter is before the court on the plaintiff's motion for temporary custody, parenting time support. Mr. Fisher.
Yes, Your Honor, as appears from the proof of service on the file, the motion was served upon the defendant father on October 17. I received an appearance of attorney on October 18th for defendant father. On October 26th, I sent an email to counsel asking the status of an answer. I was told one was working on and I would be getting it. Your Honor, I don't believe an answer has been filed to the motion. If it has been filed, I wasn't served with a copy.
Okay. An answer was filed, Mr. Fisher, so unfortunately you didn't get it.
Okay. What we're requesting today is a temporary order requesting the plaintiff mother be granted the sole physical and legal custody of the minor child, subject to restricted and supervised parenting time and defendant father. The child support be awarded based upon the Michigan child support formula, and it be retroactive back to this date. She's requesting this relief because she feels that's in the best interest of the minor child, and for the following reasons. One is, as the court knows, we're dealing with a child of tender age too, but mainly it's because an established custodial environment, both in the sense of physical and psychological sense, exists solely with plaintiff mother. The relationship with plaintiff mother with the minor child is marked by qualities of security, stability, permanence. From birth to this date, the mother's been providing the parental care, guidance, discipline, and attention to the child. And this is in part due to the tender age of the child. It's also due to the part that the defendant father either voluntarily or involuntarily has abdicated his parental responsibilities to the plaintiff mother. Plaintiff mother is the one who schedules and takes the child to doctor appointments, buys clothes for the child, dresses the child, bathes the child, arranges sitters for the child, has enrolled the child in child care, is the one who stays home with the child when the child is not feeling well. Due to the defendant father's daily abuse of alcohol and drugs, he is not mentally or physically fit to care for the minor child. He abuses it on a daily basis to the extent that his mental and physical state is impaired. The plaintiff mother on a daily basis has a very difficult time getting defendant father up in the morning and oriented as to time and place, and it's because he's hungover from the night before. If he were to have parenting time alone, this minor child would be unattended for hours or a significant period of time each morning and at risk of harm. Further, while he's under the influence of drugs and marijuana, he has anger management issues. In the presence of the child, he yells and screams at the mother and the child to the point the child yells at the father to stop it and tries to punch him. He yelling vulgar language. He's derogatory about the plaintiff mother. He slams doors, has punched holes in the walls. And as the court knows from the motion, that he has been physically and mentally abusive to the plaintiff mother, such that on September 25, 2023, the court issued an ex parte personal protection order. That order is attached to our motion, as is the petition for an ex parte PPO that sets forth facts that warranted the issuance of the PPO. I think it's significant in that the defendant father did not, within 14 days of being served with the personal protection order, or to this date, file a motion to modify it to see the child or to have it terminated. Defendant father leaves cans and bottles with alcohol in it around the home in reach of the child. He leaves marijuana accessories around the home in reach of the minor child. He has left a gun in the home in the reach of the minor child, and he's operated a motor vehicle while under the influence of alcohol, with the child being a passenger in the car. This kind of conduct is very upsetting, stressful, and anxiety for the minor child. It creates an unstable and hostile environment for the minor child, and it puts the child at high risk. I think it's important to note that the defendant father, in his answer to our petition for custody, did not answer paragraph 9 in full, and as such has admitted that his parenting time should be supervised, and admitted that his mother, with whom he resides, would be a fit and proper supervisor. I think it's also important to the court to know that since September 25, 2023, the father has not had his mother or any third party communicate with plaintiff mother to arrange parenting time so he didn't violate the PPO. He has not appeared at childcare to say hello to the child or have lunch with the child. He has not paid 1 penny of child support for the care of this child, nor any monies to help with the ownership and occupancy of the home in which they resided. Based upon this, we're asking the court for the following relief. That plaintiff mother have the sole physical and legal custody of the minor child on a temporary basis. That the parenting time be restricted and supervised, such that he not have alcohol, use or consume alcohol or marijuana or any other drug 8 hours prior to parenting time or during parenting time, that he not have overnight parenting time, and that his parenting time be midweek each Tuesday and Thursday from 4 p.m. to 7 p.m., and every other Saturday from 10 a.m. to 6 p.m., and alternate holidays from 8 a.m. to 6 p.m., and that it be supervised by his mother, Lori Reinhard, or a third party mutually agreed to by the parties. In regards to child support, we're asking it be based upon the child support formula and retroactive to this date. We're asking that the court order the parties to exchange pay stubs from September 26th to this date in order to determine support, and also order that if we cannot agree upon the support, plaintiff mother can bring the matter of child support back before this court. And again, Your Honor, I do not have the opportunity to know what the answer provides or to address any issues that she may raise. Thank
Okay,
you.
Mr. Schaefer, or Mr. Fisher, just clarify if you would with me, because you said in answer to paragraph 9 of the motion that he didn't answer that. Well, how would you know that if you didn't get an answer?
No, that's the answer to the petition for custody. I received that.
Okay,
What he didn't answer is the motion before the court today.
okay,
Well, I didn't get a copy. Evidently, he did file an answer.
okay. Ms. Huffman, what's your response?
Thank you, Your Honor. Mr. Fisher, I do apologize for the late filing of the answer. I did file it. When I filed it, I just attached it to everybody. I sent it, CC'd it to everybody, including you. So you did get it, or should have received it via email last evening. I do apologize for that late filing. So I'm not sure if you've checked your email today, but you should have it. In any event, so Your Honor, it always comes down to all of the bad things dad did in the entire time that they were together. For example, paragraph 7 states my client has been abusive since the child's birth. Paragraph 11F says, sorry, I got lost in this whole thing. Paragraph 11F says that child or says that my client abuses alcohol every day. The next one that he abuses marijuana every day. And it just goes on from there. Everything bad that my client's done since the child's birth. But if that were the case, then you would think mom would do something about it before then. It always comes out to be that one parent or the other is all of a sudden a bad parent from the time that they've known them, even though they never bothered to say anything prior. It's always that way. Unfortunately, the court's going to hear that repeatedly all day long today. The court's heard that since the judge has been a judge. The entire motion is full of accusations, quite frankly. Both parties look absolutely incapable of caring for a child. If you look at this motion, they both do. Because if my client did any of these things and mom allowed any of it to happen and didn't stop any of it or try or kick dad out or call the police or, I mean, allow him to have a gun, we're going to allow him to have a gun in front of this 2-year-old child and not do anything about that, well, then we need CPS involved, right? No, we don't. Because none of this is true. Mom is not a bad mother and dad is not a bad father because none of this is true. If it was true, I believe mother would have done something. I have to believe that. It's just her attempt to make my client the bad guy. And I think we all believe that. Unfortunately, as I stated, this court's going to hear the same story all day long today. I know better, and so does this court. So do we all. There was definitely a ruckus the night that the parties separated. But it was my client who thought that plaintiff had broken his ribs. It was my client who got his tooth broken. And it was my client whose lip was busted when she smashed his face with a Nerf gun. And the parties probably needed to separate at that time, and the PPO probably needs to stay in effect, which is why my client did not fight the PPO. He's safer with the PPO. They're better off with the PPO. They don't need to have contact with each other. It's just the way it is. That doesn't mean that the child no longer deserves to have a father or no longer deserves to have a mother. Both parties have equally cared for this child since the child's birth. My client has taken him fishing, even at 1 year old, taking him out in the boat, taking him fishing. He goes to doctor's appointments. He's given the child a bath all through since he's been born. He's changed his diapers since he's been born. Has fed the child since he's been born, picks up groceries, buys things at the store. Whenever mom asks him to go to the store, he gets up and goes. He's been just as involved in this child's life, and he picks the child up from daycare as well and takes the child to daycare. So he's just as involved in this child as mom. And if it were any different, mom would have been rid of him long ago. We have no issues with child support being retroactive to today's date, and whatever the formula is, whatever it comes out to, it comes out to. We're not going to argue that. My client admits that he used alcohol and marijuana alongside mom. He rarely used if she wasn't. They used together. And as I stated before, obviously, there was never a gun in the presence of this minor child, or I'd hope to God mom would do something about it at that time. The parties have raised this child together until their separation 1 month ago. It's only been 1 month. He is a good dad and she's a good mom. He believes that parenting time should be, for him, he could have Monday and Wednesday. She could have Tuesday and Thursday because she's off work on Wednesday. Is that right? So she could have Wednesday. And he's off Monday, so he could have Monday. And he's also off every weekend, so he could have every other weekend. They could each have every other weekend. So he would have Monday and Wednesday and every other weekend. She would have Tuesday and Thursday and every other weekend. They both work first shift. They both have the same hours or very close. They both get out approximately, my client gets out at 4:30, she gets out or gets home about 4:30. She gets home about 5 or 5:30. They would both still use the same daycare. Like I said, dad has Saturday, Sunday, and Monday off. Mom has Tuesday and Wednesday off. So, like I said, she could have Tuesday and Wednesday and every other weekend. He would have Monday and Thursday. That's what I said, Monday and Thursday, or every other weekend, right? Monday and Thursday. I'm sorry, Your Honor. We had set this up and then changed it because of her days off. So this way the child would not go very long without seeing either parent and would still go to his same daycare. The child would be picked up and dropped off at daycare, so the parties would have no need to see each other. This would be as close to the status quo as possible under the circumstances. My client does have a bed for the child. He does have his own room. He does have clothes and toys and everything the child needs. This child's bedtime is 8 p.m., so neither party is missing huge amounts of parenting time since, like I said, they both are getting him later after work anyway. I just think that's the closest thing that we can get to status quo as possible from what they were doing for the past 2.5 years. And that's what we're asking the court to do.
Okay. Well, what the court's going to do in this matter, it says a temporary order. The court is going to, on a temporary basis, can award custody to plaintiff mother. The court would award the defendant standard parenting time. The parties would meet at Battle Creek Police Department. The plaintiff obviously would not meet. She'd have to send a third party with the child because of the PPO, so they wouldn't have any contact. Court would order support pursuant to the child support formula effective the date of notice of the motion, and would order in this matter that during the time that the respective parties have the child in their care, that they not consume any alcohol or any drugs in this particular matter. I'll ask Mr. Fisher that you would prepare that order and submit it under a 7-day notice of entry.
Your Honor, I need to know what you consider standard parenting time, whether that's the option 2 of the guideline that we had or something else.
Nope, the standard, the alternating weekends, midweek, alternating holidays.
Is the midweek just a like a 4-hour visit, or is
Yes.
that an overnight? Okay.
Nope. 4-hour. Okay.
So it's not supervised, not restricted, even alcohol before parenting time?
No, that they cannot consume.
They can drink
during-
before parenting time?
they
No,
cannot
there's a no
consume-
alcohol.
They cannot consume during parenting time, correct?
Right, during, but can they consume right before parenting time?
If I said they cannot consume during parenting time, that's what the order would state. Okay, thank you. Court will conclude this matter at 9:10 a.m. You're free to go. Have a good day. Court will note the
Thank
appearance
you.
of Mr. Fernandez on behalf of the plaintiff and defendant appearing in pro per. This matter is before the court on the plaintiff's motion to show cause for denial of parenting time and for makeup parenting time. Mr. Fernandez.
Yes, Your Honor, between the periods of July 5th to July 28th, 2023, and August 9th to August 22nd, 2023, the plaintiff's parenting time was denied. The defendant was arrested for parental kidnapping, and we filed a show cause, and that was addressed. The children were to be to return, but we haven't addressed the issue of makeup parenting time yet. And we believe that the plaintiff would be entitled to at least 21 days of makeup parenting time. Thank you.
Okay, thank you. Ms. Martinez, what's your response?
Hi, Your Honor. My response is that I do not overturn anything. He had me falsely arrested for parental kidnapping when he knows full and well that me and our child left July 1st in an attempt to escape from our lives. He was violently attacking us, to which he just pled guilty to. The kidnapping charge has been dissolved. There's no legal grounds on it. The warrant should have never been signed. So Mr. Beck claims that I owe him from July 5th to July 28th. Court dockets say he didn't even get bonded out till the 14th. I can't tell you how many times, if I go through this list of allegations, how many times this man has perjured himself.
Okay. Well, let me stop you there. Sounds like we're going to need an evidentiary hearing. And we don't have time for that today, nor am I going to take any testimony today. So, but we'll
Well,
have,
I am giving my testimony. I don't owe that man
ma'am,
anything.
we don't take testimony on motion hearings. I'm listening to what you have to say, and you're disputing the charges. So we're going to set it for a hearing.
Well, no, my charges for parental kidnapping have been dropped. Mr. Beck pled guilty to
Okay.
years of spousal
Apparently, you're
abuse.
not listening to what I'm saying. On this motion, you're disputing and contesting the motion. So we'll have to have a hearing and take testimony and evidence at that particular time. So that's what we'll do in this particular matter. We'll set it for an evidentiary hearing, and we'll be able to take the evidence at that particular
Your
time.
Honor, I would just like to know that I have a child to take care of. Mr. Beck has brought me to court numerous times for these frivolous motions. Is this an attempt to see me since, I've gone no contact with him? The only time that Mr. Beck has had access to me is through your court on these Zoom hearings. I mean, how much longer are you going to allow his continued domestic abuse to continue through your courtroom?
Okay, ma'am, everybody has a right to file pleadings in a particular case. If
I
there's
get that, but I also have civil rights to be protected from my abuser and
ma'am,
false allegations.
he has a right to file pleadings. The attorney has filed pleadings on his behalf. The court has to address those. You may not like it, but legally he's entitled to do that. So
Well, let's address the lies.
the court will listen to the motion when they properly file that. So we're going to set it for an evidentiary hearing, and we'll
It's a
take
waste of
testimony
time.
at that time. Okay,
This
Thank
man
you.
needs to move on with his life and leave me the hell alone.
ma'am. Court will conclude this matter at 9:15 a.m. You're free to go. Have a good day.
Thank you, Your Honor.
Court will note the appearance of Ms. Shadowins on behalf of the plaintiff and Ms. Capture on behalf of the defendant. This matter is before the court on the defendant's motion for entry of judgment in the UCSO. Ms. Capture, have you received the answer as well?
I have, Your Honor.
Okay. You can proceed.
All right, thank you, Judge. First and foremost, I want to state that friend of the court has objected to the entry of the UCSO, but I did speak with them just this morning, and they did state that if in the judgment of divorce, the phrase, let me look at the page specifically, under child support on page, apologize.
What they're saying, if you had direct payments, that you had to opt out is what they're saying.
Yes, but they said they would not object if we struck the provision on page 4 on under child support, starting from furthermore, or the amount of defendant's contribution of Peyton's 529 account shall be reviewable, consistent. Furthermore, defendant's contributions to the 529 and the child's expenses shall be enforceable by friend of the court. If we struck that sentence starting at furthermore, they would not object any further to the entry of the judgment. I spoke with Ms. Schwab about that. She is the representative from friend of the court who objected to the
Okay, well, let's
UCSO.
address Ms. Shadowin's response where she's objecting to claiming that your client had failed to disclose various income.
Your Honor, that's incorrect. My client has produced all of his VOIA 401k distributions since 2010. The parties knew that Mr. DuPont had collected a 401k distribution. Also, if you look at the proposed UCSO, we imputed Mr. DuPont's at $160,000. The tax returns reflect this amount. It's $168,000 for his tax returns. We also imputed Ms. DuPont's at $100,000. That's because of her expert view of what her income was. And so the proposed incomes that are put on the calculations are actually very correct to what was listed on the tax returns.
Okay. Ms. Shadowin, so you heard Ms. Capture say it's all correct. So why are you objecting?
Well, we're objecting, Your Honor, because the reason it's incorrect is that based upon expert testimony, Mr. DuPont's business income was $100,000, and then the additional income from his pension and regular 401k cash withdrawals was the additional $60,000. So based upon the tax returns, his income should actually be $195,000, and that's what the friend of the court and I think everyone would use for his income based upon our agreements. And so he did misrepresent his income in addition to the pension income. Throughout the litigation, he contended that there was no Bitcoin, there was no money to be made from that. And the tax returns clearly show that Mr. DuPont in 2022 did receive substantial income, I believe around $40,000 to $50,000 from Bitcoin. And so unfortunately, the misrepresentations were revealed to us after we sort of finalized everything in terms of an agreement. And so my client believes that based on that, we should be having friend of the court go into his income, complete an investigation, and do a recommendation. And that's regards to the income. I can address the other issues relative to the objection if the court wants.
I don't need to do that today.
Okay.
What the court's going to do is the court, based upon the answers filed out, the court is going to send this matter to a referee hearing, evidentiary hearing on the issue of child support, and we can get it resolved in that particular way. And I think based upon what Ms. Capture said, then she'll be able to take care of, once we resolve that, we can resolve the other objection issues through the front of the court. So that will be the order of the court, and we'll do a referral order to the referee, and you should get notice within probably a week as to when that hearing could be held.
Your Honor, I just have a clarifying question. The issue is that the parties did agree to certain timelines. The concern that pushing this off to a referee hearing is going to violate those timelines, which is going to negatively affect my client. He's going to start incurring interest on the equalization value that the parties agreed on. It might hold up refinance, which is set to be accomplished within the next month. The parties agreed to this, which is simple. Ms. DuPont signed a settlement agreement that states that she agreed to this deviation, essentially.
Well, what you can do, Ms. Capture, is you can make the correction you had stated as it related to the front of the court issue, and then just state that the support issue will be reviewed by the front of the court, and we can get the orders entered then, but still preserve the front of the court evidentiary hearing.
All right, thank you, Your Honor.
Your Honor, I just want to be clear that my client in no way, shape, or form is going to waive opt out of front of the court. She believes that the crux of the agreement was that the amount that was being paid constituted child support and would be reviewable based upon changes in circumstances. And so I'm not sure what the front of the court told Ms. Capture to delete, but I want to make it clear that in no way, shape, or form are we agreeing, or was it part of the agreement, that child support would be waived and or that we would be opting out in front of the court.
Okay, Ms. Capture, what's your response on that?
Your Honor, if you read the agreement, the settlement agreement, Ms. DuPont actually did agree to waive child support. In fact, we're doing $200 a month to a $529. That's direct paid by defendant. That's essentially waiving child support. We deviated to zero on the UCSO. Unfortunately, I don't believe you can opt out of one specific point in front of the court. We would essentially be opting out to the accounting portion of front of the court because the monies wouldn't be going directly through. So simply that we were being creative in order to get this case settled. It has been going on now for well over a year. This case needs to be settled, and pushing it further is a waste of the court's resources. It's a waste of the party's resources. Ms. DuPont agreed to this provision. So I'm simply not sure why we need to move forward with front of the court.
Well, because they said that there's a dispute on his income, and obviously that's always subject to modification review. So the court is going to have a referee hearing to review it to make sure that it is accurate. So you can prepare and submit the new judgment and all of that under 7-day in this matter, but put a provision in that in fact the support is going to be reviewed and would be retroactive to the date of the order.
We have previously agreed that it would be retroactive to April of 2022, okay. Your Honor.
Take it to April 22 then.
Thank you.
Okay. And then you can
Alright.
submit that and we'll get that entered and that shouldn't hold up anything else. And then you'll get a hearing with the referee.
All right, thank you, Your Honor.
Thank you, Your Honor.
Court will
Have a
note
good
the
day.
appearance of
You
Ms.
too.
Thomas on behalf of the plaintiff. This matter is before the court on the plaintiff's notice for entry of revised temporary order. Ms. Thomas.
Thank you, Your Honor. Your Honor, when we prepared the order after the hearing under 7-day, we inadvertently left out the parenting restriction about drinking. And we realized that after the fact, and so because it would no longer have been within 7 days, we noticed it up for entry today. It's the same thing you've already ordered. We missed it when we prepared that order.
Okay. Mr. Boyd, what's your response?
I'm not sure what that even means. Revised, I don't know.
Well, what they said is that from the date of the, when we had the motion hearing, the court ruled in this matter, they had left a provision out, which they're including now in the revised temporary order.
Okay.
Okay, do you have any,
Okay, I won't.
okay, do you have any response to that?
I won't drink. I'm not going to drink.
Okay, well, then we've got that provision and that provision will assure that you don't, so that, that should not be an issue then. So the court
Okay.
will enter the revised temporary order as submitted by Ms. Thomas. And we'll conclude this matter at 9:28 a.m. You're free to go. Have a good day. Mr. Schaefer, on behalf of plaintiff, this matter is before the court on the plaintiff's motion to correct scrivener's error and for contempt and other relief. Court will note the defendant has not appeared, nor has the defendant responded or filed any pleadings in this particular matter. The court waited now 11 minutes for the defendant to appear. He has not done so. Mr. Schaefer.
If it please the court, Your Honor, this is the second time that we've been back to court on contempt requests. Mr. Avila, he has not complied with the judgment, and well, there's a scrivener's error in the should be 4:30 that be corrected and a corrected order be entered on the contempt order of 5/24 of 23. The contempt part of it is that the judgment of divorce set up a situation where Mr. Avila was to pay the mortgage and utilities anticipated through December of 22. At that point in time, he was getting financing and paying off of the Serby property to be deeded over to my client. He has stopped the payments on that. As a result of that, that is in jeopardy right at the moment. And so we're asking, since the last order required him to list the property on Linden Street to cover the costs on Serby Street, and he has failed to do that. He's in contempt of that court order again, but he apparently is not going to follow the orders. So we're asking for relief. The relief that I anticipate we need is that to give my client the authority to auction the Linden Street property off, and to, from that, have a lien to cover all of the expenses that he was obligated to pay under the judgment of divorce, so that the Serby can be paid off and transferred to my client. And we're asking for costs again that he's in contempt of court. So those are the requests, Your Honor.
Okay. Well, the court would note that, again, it is clear the judgment of divorce did provide that again, he would pay those costs and until the property was paid off, et cetera, or refinanced. He has not done that. The court will hold him in contempt of court for failing to comply with the judgment of divorce and the order of May 24, 2023, both of those. The court would order that the court would grant your requested relief to have the Linden Street property auctioned off as a result of his failure to comply. And the court would award you attorney fees. What is the amount of that, Mr. Schaefer?
I think we're it's another $1,000, the same as it was before, Your Honor. The preparation, the appearance, and the review. So we're going to have that amount of money into it.
Court would award to Mr. Schaefer's office attorney fees and costs of $1,000, which shall be paid within 60 days from today's date. Failing to do so, it'll be a lien against the proceeds from the Linden Street. Well, not Linden, from the Serby. It's the
No,
Serby,
no,
that's
it's-
Linden Street.
Yeah.
Okay. And also, as a favor, what the court can do is, so we don't have to wait on Mr. Avila, the court can, in that order, also transfer that property to the plaintiff free and clear of any claim on his part, so we don't have to have him execute anything to transfer the property.
Okay. Okay, very good. I will prepare that order and submit it, Your Honor.
Okay, thank you. Court will end this matter
Thank
at 9:45 a.m. Ms. Grantham, on behalf of the defendant, this matter is before the court on the defendant's motion for protective order, custody, parenting time, and support. Ms. Grantham.
Thank you, Your Honor. I believe also we answered also, in addition, we did a counter complaint. I'd like for the record to reflect that I am appearing pro bono and limited in the event that she needs an attorney for an evidentiary hearing. We did receive the complaint, and I think that it's important for the court to know that she was falsely accused by him. We have video of him making allegations that he saw in a New York case and has done this against her. So there is parent alienation. However, my client, interestingly, feels that it is in the best interest of the minor children to have parenting time with their father. She's keeping those things separate, and I have a lot of respect for her for that. But in my request, I do note that, and I stand by the counter complaint that I submitted requesting that parenting time does take place, but that we can perhaps bring this, have a referee go over this, and then also that the court recognize that both parties appear to be indigent and that they don't have money for mediation. And so I don't know if there's something that the court can help out to allow maybe the parties to proceed forward in the most cost-effective way, and then also what is in the best interest of the minor children.
Okay. Mr. Garrett, what's your response to the motion?
So basically they're saying that I made a false statement against her.
Apparently that's what she said, but you can respond to the written motion, and that's not in there.
Okay.
What she's doing is she's asking for custody, child support. She's asking that she be awarded the vehicle that she's used, and that she award some parenting time to you.
Okay. Well, it's just, quite honestly, I'm be honest with you, Your Honor. All this is over me being with somebody that she doesn't want me to be with. And on the, I believe.
Okay, sir, that's irrelevant to the case. So we just need you to respond to her motion.
Okay, so when you say respond to it.
Yes, do you have any response to her motion?
Do I have a response to her motion? I don't agree with it, if that's what you're asking.
Okay. Well, I need to know specifically what you don't agree to if you have an objection.
I don't agree to me just having parenting time, and I've had my kids on a constant basis up until July 11th. And she's been keeping them from me and using me to just give them rides to football practice and games and stuff like that. I haven't had much time with my children. But it went from me having my kids every day. That's why they go to school from my house. Well, they were going to school from my house. Literally, my house is around the corner and down the street from the school. And for some reason, they have 12 and 24 unexcused tardies because she's not capable of getting them to school on time, which they didn't have that issue when they were with me, and it was right around the corner from their school. Yeah, I can't believe that we really even here, because she really doesn't care as much as she's acting. I opened a CPS case on her because she abused my daughter. She put her in the corner, and when she got to crying, she smacked her.
Okay. And what's happened with regard to that investigation, if you know?
I'm not sure. They haven't really gotten back to me. I got word that they closed the case, and I don't really know how they closed the case, and they haven't really talked to me about anything else.
You'll have to check into that, and then you'll have to respond on your pleading, sir, so that we have some evidence or information. Okay, anything else?
Yes, yes, Your Honor.
No, I'm asking Mr. Garrett.
Simply, my kids don't want to be over there. They don't want to be where they're at. She doesn't have a job. She doesn't have transportation that's reliable. And the environment that they're in is not the best environment. They're not learning anything positive where they're at all. My daughter was just telling me the other day about they're having a stripper party that their mom was going to and all that. They her at the house.
Okay. Yeah, you can't say what the kids say, sir. That's hearsay. It's not admissible.
Right.
Okay. Anything else, Ms. Grantham?
Yes, Your Honor. I'd like a temporary order granting the defendant mother full physical and sole legal custody until the parties can go before the referee or have an evidentiary hearing or mediation, whatever happens first, and then grant a protective order that the plaintiff father cannot tow the defendant mother's car as he has already tried to do, and that reasonable parenting time be granted to plaintiff father. Currently, he is having parenting time, but that during the parenting time, the general provisions that he cannot involve the minor children in his dealings, he cannot browbeat the minor children into being his sole investigators, and that we order an evaluation of the parties and the minor children due to the surrounding circumstances, and that plaintiff father to pay child support for the 3 children that have been residing with defendant mother based upon the Michigan child support guidelines, and that the court proceed with mediation in whatever form is available due to the indigency of both parties. Thank you.
Okay. Well, what the court is going to do on a temporary basis, the court will grant to the defendant temporary custody. Will grant child support pursuant to the child support formula. And it is stated that the defendant is not working, and I've not seen anything in the pleadings or mentioned as to why she couldn't. So the court would impute minimum income of $15 per hour for 40 hours per week. The court would order that the defendant has right to possession of her vehicle. The plaintiff will not have the vehicle towed or threaten to have it towed or anything. Court will order, it sounds like based on the paperwork that the plaintiff had the children every weekend. So the court is going to grant him parenting time from Friday at 6:00 p.m. to Sunday at noon, because it said in the pleadings that he had him until Sunday morning. And the court would order that neither party would discuss these proceedings with the children or involve them in adult matters. And I'll ask Ms. Grantham that you would prepare that order and submit under 7-day notice of entry.
Yes, Your Honor. Thank you.
Okay, thank you. Court will end this matter at 10:11 a.m. You're free to go. On behalf of the defendant, this matter is before the court on the defendant's motion to show cause. In this matter, I take it from your motion, Ms. McNiff, that what you're seeking is an evidentiary hearing to address the contempt issue.
Correct, Your Honor.
Okay. Ms. Johnson, what's your response? You're muted, ma'am.
Let's see, unmute.
Hey, I think I got it.
Yes, we can hear you now. Go ahead.
I have been in Lansing for a few weeks in and out of the hospital. I wasn't able to send in my answer, but I did screenshot and invert the photos so you guys can see why there was so much traffic. And
okay, it's reversed, so I can't read a thing backwards.
Let me see if I can.
Well, what's going to happen, ma'am, is
there was a
hold on. They're asking for an evidentiary hearing, so we can take care of that at an evidentiary hearing. You can present any proofs at that point that you want to present. So the court will just set the matter for an evidentiary hearing, and we can present everything at that time.
Thank you.
Okay.
We'll be in touch with you and clear the date so that everybody's available, and then we'll have a hearing. Okay, thank you.
Thank
The
you.
court would note that the matters before the court on the defendant's motion to set aside referee recommendation in this matter. I guess I don't understand, sir, your objection is it says me and plaintiff agreed condition. And I don't know what that means.
Me and the Kara agreed on it. She filled this out, and we both signed it and agreed with it.
Okay, and I take it that whatever you agreed to, you say varies from what the referee ruled. Is that correct?
Yeah. So it's I don't know if you can see it, Honor.
I can't see it, sir. So holding it up like that's not going to do anything for me. It just looks like there's some writing on a piece of paper.
Okay, it just says me and Carol agreed to take off supervised visit, and if they're yelling, to send her upstairs to my apartment 5. Then when her and her boyfriend are done, I will send her back down. And Angel stays Saturday into Sunday overnight. And it says Akara Wiggin and Jesse Spinlow.
Okay. Ms. Wiegand, what's your response to the motion?
I only signed it because I felt like I was being forced. And another thing is, he no longer lives in the same building. He moved back to his mom. So it'd be impossible for us to do that agreement.
Okay. Okay. Well, what's your response to that? You move, sir?
Yeah, I moved because me and the defense couldn't get along and stuff like that. So I just moved for make peace for me and her dealing with the child. And she stayed overnight twice while I lived there. She stayed in the overnight.
Okay. Well, what I'm going to do is, again, you haven't set forth any factual or legal error that the referee made, and I can only set aside the referee order if, in fact, the referee made a legal or a factual error in the case. So I'm not in a position to be able to do that at this particular time, being again not apprised of any error that the referee made. So I'm going to, unfortunately, sir, I'll have to deny your motion at this time. You always have a right, if circumstances change, you always have a right to file a motion to modify that order. And so if they change, I would recommend that you file the motion for modification, and we can take it up at that time.
All right.
Okay. Thank you. The court will end this matter at 10:36 a.m. You're free to go. Have a good day. The court will note that this matter is before the court on the plaintiff's motion to transfer a case to Kalamazoo County. Ms. Kindred, just for your information, is pursuant to court rule, and that's court rule MCR 3.212 parens B parens 1. The court cannot transfer a case to an adjoining contiguous county, which would Kalamazoo obviously is an adjoining county to Calhoun County. So pursuant to court rule, I can't grant your requested relief because I'm not able to do so.
I'm not understanding why that can't be when I was never awarded any summons to any of these court cases on these decisions.
Well, that's independent of your motion. Your motion is to transfer the case. You haven't filed anything as it relates to any other notices or things of that particular case. So all I'm telling you is pursuant to court rule, I cannot transfer a case to Kalamazoo County because it is a contiguous county to Calhoun. So unfortunately, I can't grant your requested relief. Okay.
So I can't transfer neither.
What?
I said, so I can't transfer either one of my cases.
That is correct. Because you're seeking to transfer it to Kalamazoo County. And as I stated, that's a contiguous adjoining county, and I can't, pursuant to court rule, I can't do that.
So I got to just keep filing motions that's being denied and nobody's looking at the paperwork?
You have to file in Calhoun County. And if you have a basis for your request, the court will consider that and will set a hearing if hearing is necessary. But the only thing we're on today is your motion to transfer, which I cannot grant.
So what was it that I filed?
Excuse me?
I said, so what is it that I filed? Like what, like?
Well, it's up to you. A motion is a request to the court. You can request anything. Doesn't mean it can always be granted like you're finding here. You can't transfer the case because the court rules don't allow it. But you can file a motion for anything that you want in a case. You just have to file in the appropriate county, which would be Calhoun.
So basically just file just a motion, like this still doesn't make any sense to me.
Well,
because the problem is when we file there, everything is being dismissed, but they're willing to help here.
Well, you cannot transfer it to Kalamazoo County. I just can't do it. If I did it, the Court of Appeals could come in and say, Judge, you made a mistake. We're reversing you and sending it back to Calhoun County. So there's nothing that I can do at this point to transfer the case. And if you're filing something in Calhoun County, you have to file a proper pleading. If you filed something and it's being dismissed, then whoever, if it's a referee or whatever, is stating that that's not proper. And I don't know because that's not before the court today. It's only your motion to transfer. So I am going to deny your motion. Sir, you're going to have to do an order denying motion and submit that to the court under a 7-day notice. So submit under a 7-day notice of entry, and we will get that order entered at that time. The court will conclude this matter at 10:41 a.m. You're free to go. Have a good day.
Do I stay on? I still need to call the other case.
Court will note that this matter is before the court on the plaintiff's motion to transfer the case to Kalamazoo County. Mr. Etchison, I'll just give you some background. Ms. Kindred had attempted to transfer another case to Kalamazoo County as well. I informed her that pursuant to Michigan Court Rule 3.212, parens B, parens 1, the court cannot transfer a case to an adjoining contiguous county. So I have no ability to transfer the case to Kalamazoo County. That would ring true for this case as well. So what the court's going to have to do is deny the motion as it doesn't comply with court rule, and I can't do what she's requesting. So the court will deny the motion to transfer. Mr. Etchison, as I've denied that, you're going to have to do an order denying the motion and submit that under 7-day notice of entry. So just do an order stating that we had today's hearing and the court denied the motion to transfer the case to Kalamazoo County. Okay?
Okay. So where do I get that from? The courthouse?
What you can do is if you're looking at, you can go to michiganlegalhelp.org. It's a service, just has all pleadings on their site, and you're just going to have to do an order, just order denying motion. I don't know if they have something to that effect, but they should. So look at that and then do the order and submit under 7-day notice of entry. Okay. Okay. Thank you. The court will end this matter at 10:43 a.m. You're free to go. Have a good day. Court will note that this matter is before the court on the defendant's motion in regard to custody. Court would note that there was a judgment of divorce entered on October 2nd, 2023. Sir, as I look through your motion, many of the allegations you have precede the entry of the judgment of divorce. In these cases, when you're seeking modification, the court can only go back to the last order, which would be the judgment on October 2nd, 2023. I can't go a month back. I can't go a year back because everything is merged into the entry of that particular judgment. So that's all we can look at. And quite frankly, as I look at it, there's not been really sufficient changes which would justify or amount to proper cause or change in circumstances to meet the Vadvarka threshold to even have an evidentiary hearing. So what can you tell me?
For one, what I'm saying is I'm paying child support. I'm married. We no divorce, no nothing. But I'm paying child support based off whatever and they have with her, saying that my kids have not been with me, don't stay the night or anything. And like literally not to put you like my kid stays with me, like literally stays
Okay.
with me. Them two is 6. I don't feel like I'm supposed to pay child support or she shouldn't have sole priority while we're married, still on good terms. And like literally we at each other's houses every day.
Okay.
So that's what I'm saying.
What you're
Like,
going
all
to
of
have to
it-
do, you filed for modification of custody. You're going to have to file seeking a modification of child support. And you're going to have to allege what's happened since October 2nd, or the court wouldn't have any basis to do that. So just file a new motion from October 2nd, alleging what's happened. If you've had the kids since that date, delineate in the motion when you've had the kids, what overnights, et cetera. And then the court can, in fact, look at that point, but I can't do it on a motion for change in custody.
Yeah, I don't know. I did what I was told. Like far as, and this is my question. Hold on, I know. My question is, okay, this is October, the end of October. I've been having my kids since I came to court August 2nd. I've been having my kids, but I don't understand why the dads have to go through all these loops to prove anything.
Well, it has nothing to do with men. If it was a woman, she'd be having to do the same thing, sir.
So what type of, my question, I'm sorry to cut you off. What type of proof did she show you guys that my kids have not stayed with me there?
What happens, you're going to have to do a motion from the October 2nd date and delineate what the days are that you've had the kids since that date for modification and child support.
I understand what you said. Well, I'm saying I'm on child support now, and she took sole priority off for what proof did she bring besides a verbal statement? That's what I'm saying. I'm going through all that. We are legally married. We are together.
I don't know, because again, what we're going from is from the date of the judgment of divorce. So I'm not going into anything before the judgment of divorce.
We don't have no divorce. You keep saying, yeah, this is my name, Terrell Bolden.
Yes. Okay.
I don't have a divorce.
Okay, so you had a judgment of custody then. I had it down as a judgment of divorce, but
it was custody and it was child support.
Okay. Well, we go from that date. So what you have to do is you have to establish what's happened since the October 2nd date moving forward.
And what you mean, like, what do you mean establish? Like, what do you mean? Like, I should never been on child support even on October 2nd. Like I've been living with my kids since they've been born.
Okay.
You see that guy? You see this guy in the background? That's my son. Okay. This is my daughter. They both got rooms. Okay. I got 4 kids.
You have to state what's happened since October 2nd moving forward as to when you had the kids, how often you had the kids, and then the court can look at the support issue after that particular time. But your motion was to change custody. So I can't change support if you file a motion to change custody.
I did both, sir. Your Honor, I did on there. I did exactly. I'm not a lawyer, so I did exactly what a friend of the court told me to do. And it was you said October 2nd.
File a motion at this point, motion for modification of child support. And as I said, set forth everything that you need in there as a basis why the court should change child support.
And change custody. Far as why this is not just for child support, it's for child support and custody. Far as me and her should have equal, like we are legally married. My wife.
Okay. What you have to do is you have to set forth the basis for your request. I can't just come to the hearing and say, oh, okay, you brought all this stuff up then now. You have to set it forth in the motion. She's entitled to due process notice as delineated under your motion.
What does that mean? Like, why am I on child support right now? And my kids,
because the order, the judgment says you have to pay child support. That's why you're paying child support. You have to modify that child support order.
Okay, I hear what you say. You told me. You told me I have my last word with you.
File a motion for modification of child support.
Okay, but far as custody, we don't have to do anything. Like my kids live with me. My son can tell you right now. He did she come and go when she wants to. I've been having all of my kids before October 2nd. That's what I'm saying, man.
Well,
I'm going.
Okay, you didn't say that in your motion. You got to delineate it in the motion so that she has notice of it. She has a right to respond to that, and the court would then have the information I need to be able to determine whether there's a basis for modification since October 2nd.
This is the third court she did not show up to that she's been served, Your Honor.
Since
I'm going-
October 2nd, file a motion since what's happened October 2nd.
I have done that, right?
Okay.
I put on there and I gave you my
No,
proof.
your allegations preceded the entry of the judgment. All your stuff is said, oh, we did this and we've been together since the kids were born. That's not the basis. I can only address what's happened from October 2nd
So
to
what's
the
the
current
basis?
day.
That's what I'm asking. Like, what is the basis of me doing anything so this stuff can be turned over? Like, what did she do to put me on child support, and what do I have to do to prove that my kids live with me? They live with me.
Then you have to
Stay with me.
spell that out in the motion, sir.
Yeah, man. I built my motion. I said they live with me. My kids live with me, man. Live with me, like literally live with me.
Okay.
I don't know how to prove that. I sent you pictures of their room, and I have my kids.
And none of that's relevant. Anybody could have pictures of a room. That doesn't mean anything, sir. You have to spell it out in the motion when you've had the kids. And
I have them every day. I have them every day.
Okay.
Anybody can write. Listen, I'm not to argue with you. I can write on my motion. I have my kids 365 days, 7 days a week. What does that do versus what she said? She said 0 nights. So now it's my word against her word. And then what you have the letter of the
then what we would
school.
do, we would have a hearing, and at that hearing you could present witnesses that could in fact testify, yes, he's had the kids since the October 2nd date, and they could testify, yes, I've been in his home on, whatever. Let's say I've been in his home so many days. I've had he's had the kids in his custody these overnights, et cetera. And then we'd have a basis to proceed. We don't now without having a specific motion. And then we have to get her served. If she doesn't respond, then it makes it real easy at the next hearing.
You said that last time. You told me to do it again. And this is the third time she did not come to court.
Well,
Your Honor, I am married. We lived together since until last year.
Okay.
I did everything you told me to do, Your Honor. I ain't trying to argue with you, man. But listen, man, I'm married and I live with my kids. I took my kids in. I lose my job because I'm with my kids, man. I'm with my kids more than she is.
Okay. Well,
saying, man,
file a motion, spell it out so the court has those dates, and then we'll be able to address that. Okay.
I spelled it out on this motion and told you that my kids live with me. Do you not see that?
Don't just say the kids live with me. That means nothing to me. Kids live with me. They lived with you yesterday. They lived with you the day before. Spell it out.
Since they was born.
Spell it out as what's happened since October 2nd. Okay. October 2nd, 2023 to the current date, the date of your motion. Spell out the times that you've had the kids. Did you have them during the day? Did you have them overnight? What's happened? You've got to do a complete, thorough motion or I can't respond to it. Okay. And just saying I've had the kids since they were born means nothing, sir.
They live with me. We've been living together. Like,
okay. I went through it. I'm not going to keep going through it. We're going to end this hearing because I've told you at least a half a dozen times what you have to do.
Okay.
File a motion.
You're right.
File
so this is the third time not showing up. If she don't show up the next time, what else gonna happen? Because you told
File
me this
a
time,
motion.
if she don't show up, who's gonna turn it over?
I can't say what's going to happen next time. I don't know what's going to happen because I don't know what she's going to do. File the motion and we'll address it at that time. Court will end this matter at 10:55 a.m.
Attorney Schaefer for plaintiff and Attorney Greenlee-Core for defendant.
Good afternoon to both of you.
Good afternoon, Judge.
Court set this for status conference as a follow-up to, again, the hearing we previously had where the court ordered the matter to counseling. And I wanted to get back together to see that were we able to pick a counselor or what's happening in that regard?
I think we've picked a counselor.
You think you've picked a counselor? Okay.
Well, we have. Well, let me bring you up to date. And opposing counsel hasn't got the last word. She had sent over a suggestion that be Kalamazoo psychological psychology, and we agreed to that. And then she asked that I contact them, and I did contact them last week. She had given me the name of a Nicole Allen, and I inquired. Nicole Allen is leaving the practice. So when I talked to the So when I talked to the director or whoever answered the phone there, she said, we have one other person by the name of Becky who was to get back to me with the details of to when, how, and what, and I have not heard. So that's as much as I know about it at this point.
Okay. Ms. Greenlee-Clore, what are your thoughts?
We were trying to find someone that was available, and that's why we finally came to Kalamazoo Psychology. So that's news to me that Nicole Allen's leaving the practice. But I think we're open to anyone at this point. So if Becky is available and willing, we need to do that. We just need Mom to do something because she hasn't done anything that this court has ordered yet. So in our opinion, so we need Mom to actually be on top of this and actually get this child into counseling. And I just want to also note for the record that the counseling is one of the reasons Mom initially used to keep temporary custody of this child. So now we're putting this child in counseling, even though that was the reason Mom said, hey, I don't want the child going back to Dad in the first place. So, but we are open to counseling. We want it to happen. Mom clearly has the child. She hasn't allowed any contact with my client at all. So this is going to be on her shoulders to get this done.
Okay.
Well,
Ms. Greenlee, if you could call the counselor's office, maybe you could check up on it too and get through to whoever this Becky is. And
do you have a last name, Tom?
I did not. I'm not sure they knew, other than it was somebody who did counseling with children and parents. And because that's what I think we needed. And they said, yes, this Becky can do it. They'll get back to me. And that was on the 26th, the last conversation that I had with them, and I haven't heard back.
All right, I will follow up after the meeting, after the hearing today, and I will see what I can find out.
Okay.
And
okay.
Yeah.
If you would just contact my office when you know if this Becky is going to do it, then we'll get a schedule as quick as you can.
Yeah, Judge, just for your information, from my perspective of checking around other places, there's not much available.
No,
within a reasonable period of time.
Yeah.
I checked all of Battle Creek, and it was 3, 4, 5, 6 weeks out before they could even talk to you.
Yeah, I had a contact with Kalamazoo Psych, and that's why I called them. So I will see. I'll reach out to them again, see if I can.
Yeah, see if you can, and see if you see if we can't expedite it and get. If we can't get an appointment set up right away, maybe we can get on a cancellation list so that we can get it done quickly.
Yeah. Okay.
Okay. Thank you. I'll let you go and have a good afternoon.
Okay. Thank you. And Tom, I'm going to call you right now on that other
PM,
case too.
Attorney Grantham for defendant. Plaintiff is not here.
Okay. Well, we're a little bit early on this, so maybe we'll put you back in the waiting room, at least wait the 5 minutes so we don't start before 1:30 because we don't know if the.
We do have it set for 1:15.
Oh, 1:15? Okay.
Yes.
Sorry,
everything is 1:15.
I had it listed down for 1:30, so. Okay. Ms. Grantham, tell me, I know we talked briefly on that when we had the motion hearing this morning about some things, and you're saying the clients can't afford mediation. We did have a mediation entity that would do it based upon ability to pay. We haven't used them in quite some time, but we can always appoint that entity to do it, or have the mediation clerk sign somebody that would do it, based on a needs analysis or something of that nature.
I think that would be perfect. So I did get updated that my client does have a job, and he's going to supply to me her pay stub. She believes it's between $13 and $14. So I will update the court but I'm assuming that the mediation that you were referring to, that it's based on the ability to pay, they're the ones that I would work with as to her income.
That's fine.
Okay. I think this is pretty simple and straightforward. It's just a matter of maybe letting a mediator kind of help through that process.
Right. Do you anticipate any discovery in the case?
Well, I was informed that the plaintiff does have a job answering government phones and tablets, but it's unclear as to where that's at. So that would be really the discovery for that as to where he works. And outside of that, I don't think so, Your Honor.
Could you do it by December 1, do you think? Get that information?
I believe so, Your Honor.
Okay, I'll put down December 1. If there's a problem, let us know, and then probably set it for a mediation in January, because I don't think you're going to get into a mediator prior to that time anyway.
Yeah. So will I get something in the mail or an email to like kind of tell me who I'm calling to set us up?
What's that?
Would I be getting something? I'm sorry, I have COVID. I'm kind of recovering. Would I be getting something by mail or email?
Yeah, we'll send you a scheduling order.
Okay.
So you'll get that. And then
also one more, Ms. Grantham, one thing. Krista did try to call the number that you gave her for plaintiff, but it didn't work. But doesn't seem like it's a big deal that he's not here. So
Okay. What I'll do is I will mail him whatever it is I'm going to be sending a discovery request for his employment anyway. But
we will mail out the completed scheduling.
Okay.
Or we will send it there.
Okay. We'll send it. We will set it for a settlement conference on February 5th, 2024 at 1:30 p.m. Parties are required to be present at that time, but it will be by Zoom.
Okay. Thank you so much. I appreciate it.
Thank you. You have a good day.
So thanks, Your Honor.
Okay.